So another interesting aspect of remote trials is that often the option is presented to give direct testimony by affidavit as opposed to live, on video testimony. And that's how it was done in the remote trial that you and I did together. Sometimes you're given the option, do you want to present testimony by affidavit or in person? And so if you're given that option, how should attorneys think about that?
It really would depend on the type of case and the type of witnesses. And my decision as the attorney would not be always, the same one. In the case that you and I did together, I remember when the judge ordered that testimony would be by affidavit. At first we were a little concerned, but ultimately we thought that it turned out pretty good because that was a case involving complicated scientific testimony from world-renowned experts on gene therapy. And it was appropriate and helpful to have written testimony for that kind of material. But I could see other cases, where even if it's a bench trial, where it's really a matter of a he said, she said, it's, the most important part of the case is deciding credibility between the witnesses. And I think in a case like that, doing direct testimony by affidavit would be much trickier. I might be reluctant to do it. What do you think? Which one do you prefer?
What I do like about direct testimony by affidavit is that, when we're doing a trial, sometimes, we lose the big picture, which is what we're really trying to do is get the story in, get all of the facts in, and then allow the fact finder, in a bench trial, the judge, to decide how those facts should be applied and what the law is about those facts. And so when you are able to put in an affidavit in place of, having in-person direct testimony, you can just have each witness testify as to the facts and their story, and then that comes in. On the other hand, as you said, if there are complex emotional issues or areas where it's really more so, not necessarily that straightforward, I think it could be harmful to do direct testimony by affidavit. What are some of the potential downsides that you can see to direct testimony by affidavit?
So we've mentioned, a little bit a couple, but the first thing is that you need to be sure that someone's going to read these things. I kind of say that jokingly, but I think some material is easier to assimilate if you have a witness talking about it as opposed to just, reading it on a piece of paper. But the other, and I think really the main downside, is that then your direct testimony is really not flexible. You've locked in your client into their testimony, and that could be a problem if your client is, say, the 7th or 8th person to testify in a trial. If you're not doing direct testimony by affidavit, in a situation like that, you almost definitely change the direct testimony based on what else has happened in the trial to that, up to that time, by the time your client takes the stand. If you've done direct testimony by affidavit, you're locked, and so that would be an obvious downside. In the remote trial that you just did, how did you decide one way or another if you were going to do direct testimony by affidavit or by live testimony on the camera?
So in that trial, what the judge did and what I would hope to see even more of going forward is they gave all of the parties the option. You could present testimony by affidavit, you could present testimony in person, or you could do some combination of the two. And so in that trial, there were some additional witnesses, but our main witness was our client, and we did both for him. And I think something that really benefited and allowed us to make that decision is that the judge set forth a very specific schedule for the direct testimony affidavits. And what I mean by that is this. He said that all of our affidavits were to be provided to the other side about 3 weeks before the trial. And we gave them to the other side, not in a PDF form, but in Word format, Microsoft Word. And then the other side actually went through that affidavit, there was only one in this case, and they put in comment bubbles using the Word software their objections to anything that they objected to, whether it be testimony or exhibits within the affidavit. And then they provided that to the court about 2 weeks before trial began. And then after that, the court actually, before the trial ever began, went through the affidavit and ruled on those objections. And so we received those rulings on the objections within 3 or 5 days before trial was going to begin. And so going into trial on that Monday morning, where we knew that our client was going to be the first witness after openings, and we knew that we were going to do some additional testimony from our client live, even without any objections. But then we knew which parts of his affidavit the judge had sustained objections to, and therefore weren't in evidence. And maybe some of that we could leave out, but maybe some things we wanted to try to approach in a different way that might not be objectionable. We were able to really make sure that we got all of the relevant facts and evidence in that we thought were important to our client's case.